decisions also in this regard. They have, this is what I'm saying, that the contact is, they haven't even bothered to say that it was based upon an
How many times you are repeating? Do you think this court will not understand?
Your Lordship, I'm sorry, may I invite my Lord's attention to...
By the respected council, it is not binding.
This was a concession in that...
Correct, it is not binding on the parties.
May I invite my Lord's attention to a decision on which I want to place reliance upon for this very...
Lord, can you see the order dated 2/11/2022?
Huh?
2/11/2022.
What is that?
Appeal against the Honorable Pinkerton Milord. In this case, Milord, departmental and order of removal before the Honorable Single Judge Milord. And the Honorable Single Judge had decided only the no perjury officer are appointed. Only inquiry officer act as a prosecutor and adjudicator, Milord. But at that time, there was no provision of perjury officer, Milord. Can you see the audio?
Respondent, Ram Vilas Chaudhary died on what date?
He has already been substituted now.
No, he died on what date?
I didn't course of...
Right to 232 and file substitution petition after lapse of 9 years, 2/11.
Huh?
After lapse of death of the her husband, substitution petition was filed in 2020, 11 below. After lapse of 9 years below.
Presenting officer was not appointed.
But and that way there was no provision in the CISF rules, my lord.
Huh?
It was inserted in 2003, my lord. I have got that notification.
Then who will present the departmental version?
Inquiry officer had decided.
No, yeah, how can the inquiring officer play the dual role of deciding the inquiry matter and presenting?
There is no provision for presenting officer, my lord. It was added in 2003, my lord.
Whatever it may be, sir.
Can you see the budget notification?
Your Lordship, may I?
What are these judgment?
Yes, Your Lordship, may I?
DLR 243.
Your Lordship, I'm raising an objection with regard to the maintainability of this LPA, my lord, a preliminary objection.
Maintainability of?
The LPA, given the peculiar facts and circumstances of the case, the Union of India, before the learned single judge, had conceded in fact, my lord, that the inquiry officer had compromised his position by acting as the prosecutor as well as the adjudicator. And on the concession made in fact, which as distinguished
Admission
from
in-
concession in law,
In writing?
will bind the Union
Writing?
of India. Yes, Your Lordship, it's recorded in the, I should invite my lord's attention.
Has he given by the respondent in writing?
It is recorded in the order.
Undertaking given by submission made on behalf.
No,
Please
Your
listen,
Lordship.
listen.
Not in writing, not in writing.
Therefore, it is not this one.
Then I may take.
Not be a hurdle.
Then may I invite my lord's attention to certain decisions
State-
on which I shall be placing reliance, my lord.
You are not listening what we can do.
My apologies.
If any undertaking given by the respective council, it is not binding.
This was a concession in fact.
Correct, it is not binding on the parties.
May I invite my lord's attention to a decision on which I want to place reliance upon for this very, to impress upon my lord, this very point.
Give the decision.
Yes, Your Lordship, I have already given the citation. The first decision, my lords. They may not have given any undertaking in writing, but the facts which are recorded in the impugned order will be taken as conclusive and binding, and the Union of India, not that they have bothered to resile from that statement. They have not even bothered to resile from the concession, in fact. They could not have.
It's a question of law, madam.
Yes, Your Lordship. in this regard, may I invite my
Therefore,
lord's
whatever the undertaking given by the learned council is not binding on the respective parties.
I humbly would want the opportunity to persuade my lords that the Union of India would be bound by this concession.
Now he has gone to bring the book from the library.
I had given the list of
Who is
books,
here? Kindly sign here.
82 to SEC. May I place this decision now? Particularly relying on paras 1, 2, 3, and 4.
Para?
Paras 1, 2, 3, and 4. Para 1 narrates the facts of the case. 2, 3 notes the concession which had been made before the Honourable High Court, and the views, the ratio laid down by the Supreme Court in Para 4. May I place the facts, my lord, in brief, before I take my lord's attention to the ratio laid down by the Supreme Court in this regard.
Which is the relevant paragraph?
The relevant paragraphs are 1, 2, 3, and 4. Just a brief overview of the facts, if I may, please, my lord, before I place reliance on the ratio that was decided. A complaint had been filed against the then Chief Minister of Maharashtra, Mr. Anupulya. This complaint was rejected by the Metropolitan Magistrate for want of necessary prosecution. The complainant approached the Honourable High Court in criminal revision, and the criminal revision was also dismissed on this very ground. However, before the dismissal of the criminal revision, the Bombay High Court was informed, my lord, that an application had been made to the governor for obtaining the necessary sanction to prosecute the then Chief Minister, my lord. And the states of Maharashtra and Mr. Anatolya were also pleaded before the Bombay High Court. Now, while disposing of the application, it was recorded by the High Court on the concession made by the Advocate General that the governor will exercise his discretion in his individual capacity and not after consulting the law minister and or any other minister. Now, the state of Maharashtra preferred an appeal under Article 136 before the Supreme Court, contending that the Bombay High Court could not direct the governor to exercise his discretion this way or that way. But since the concession had been made by the Advocate General, and on that submission, this particular recording had been, this particular observation had fallen from the Bombay High Court. Malum, when the state of Maharashtra challenged the Bombay High Court's order, this is what the Supreme Court had to say. May I read?
Read.
I'm reading paragraph 4, my lord.
Paragraph 4.
When we drew the attention of the learned Advocate General to the concession made before the High Court, Shri A.K. Sen, who appeared for the state of Maharashtra before the High Court and led the arguments for the respondents there, and who appeared for Shri Anatolya before us, intervened and protested that he never made any such concession and invited us to peruse the written submissions made by him in the High Court. We are afraid we cannot launch into an inquiry as to what transpired in the High Court. It is simply not done. Public policy bars us. Judicial decorum restrains us. Matters of judicial record are unquestionable. They are not open to doubt. Judges cannot be dragged into the arena. Judgments cannot be treated as mere counters in the game of litigation. We are bound to accept the statement of the judges recorded in the judgment as to what transpired in court. We cannot allow the statement of the judges to be contradicted by statements at the bar or by affidavit and any other evidence. If the judges say in their judgment that something was done, said or admitted before them, that has to be the last word on the subject. The principle is well settled that statement of fact as to what transpired at the hearing recorded in the judgment of the court are conclusive of the facts so stated, and no one can contradict such statements by affidavit or other evidence. If a party thinks that the happenings in court have been wrongly recorded in a judgment, it is incumbent upon the party, while the matter is still fresh in the minds of the judges, to call the attention of the very judges who have made the record to the facts that the statements made with regard to his conduct was a statement that had been made in error. This is the only way to have the record corrected. If no such step is taken, the matter must necessarily end there. Of course, the party may resign, and an appellate court may permit him in rare and appropriate cases to resign from a concession on the ground that the concession was made on a wrong appreciation of law and had led to gross injustice. But he may not call in question the very fact of making the concession as recorded in the judgment. Before I invite my Lord's attention...
No, is it their case that they did not make any concession before the single judge?
No, they have not even, not at all.
Then the cited decision is not applicable.
Your Lordship, that cited decision...
Cited decision is not applicable.
They will not be allowed to make that, they cannot resign from the statement. My submission is they haven't even bothered to resign. They have filed an LPA on the very ground which they had conceded before the learned single judge. And the same is recorded. The records had been...
They are not disputing, stating that we have not considered before the learned single judge. In that event only this decision is applicable.
Your Lordship, that this is, to the best of my understanding, if I may humbly submit, this decision only says that they will not, the facts that are recorded will be conclusive, will be taken as binding.
There are decisions that whatever the concession made by the respective councils are not binding on the respective parties.
Your Lordship, then maybe permitted to make some other decisions also in this regard. They have, this is what I'm saying, that the conduct is they haven't even bothered to say that it was based upon...
How many times you are repeating? Do you think this court will not understand?
Your Lordship, I'm sorry. May I invite my Lord's attention to what has been recorded by the learned single judge?
All right, you cite any other judgments?
2012, volume 13, SCC, page 188.
It's 2011, my.
2013.
No. It's 2011, sir.
I said 2013. Then 2013 is written.
Paragraph.
Paras 2, 12 and 13. May I please read the fact, the context in which the concession was made?
No, you take us to the finding.
Yes, Your Lordship. Para 12. The moot question is whether the appellant should be bound by the statement made by his counsel before the High Court that the respondent tenant will be re-inducted in legal area in the newly constructed building within 1 month, that is on so-and-so, from the date of completion of construction work so-and-so. From the tenor of the statement made before the High Court on behalf of the appellant, it is obvious that it is an unequivocal statement made by the counsel engaged by the appellant to espouse his cause before the High Court. It is not the case of the appellant that he had expressly instructed his counsel not to make such a statement. Further, the statement was in respect of the commitment of the appellant toward the subject matter of proceedings in which the counsel was engaged and instructed to appear. Not only that, right from the beginning and even before this court, an attempt was made by the parties to explore possibility of working out an amicable solution, as is evident from order dated so-and-so. Para 13. Considering the above, the appellant cannot be allowed to resign from the statement made before the High Court, which the High Court justly declined to undo in the review petition filed by the appellant for that purpose. In the peculiar facts of this case, the decision of this court in so-and-so will be of no avail to the appellant, inasmuch as it is not a case where the counsel who made the statement was not engaged by the appellant before the High Court. The engagement was in respect of the eviction proceedings, and the statement was in relation to the commitment of the appellant qua the subject matter thereof, and being an unequivocal statement, it will be binding on the appellant. In any case, even this court showed indulgence to the appellant on the basis of the impression given to this court about the possibility of at least sparing a small room for the respondent, which was the basis for issuing the notice to the respondent as is.
Yes. Next.
2011, volume 12, SEC, page 658.
658. Paragraph.
Paras 12, 13 and 14. May I read, my lords?
Yes.
Apart from all these material aspects before the High Court, both parties, including the plaintiff, present appellant, agreed for a reasonable market valuation. This factual position is clear from Para 7 of the High Court judgment, which reads as under. I'm skipping that one, my lord. The statement made by the counsel before the High Court, as recorded in the impugned judgment and order, cannot be challenged before this court. The relevant citations. It is also clear that the High Court has recorded in the impugned judgment dated so-and-so that the counsel agreed with instructions from the plaintiff and reiterated this fact in its order dated so-and-so and miscellaneous civil application dated so-and-so in the aforementioned RFA, while rejecting the plea of the counsel for the appellant herein that he did not give consent, that he had no instructions from his client. A concession made by a counsel on a question of fact is binding on the client. But if it is on a question of law, it is not binding, and the relevant citation.
Now, is it not a question of law, present case, in not appointing presenting officer?
It is both a question of law and a fact, my lord. But on the facts of the case, they have conceded that the inquiry officer compromised his position.
That is the reason in the beginning itself, we mentioned that it is a question of law.
Your Lordship, I humbly submit that after going through the records of the case, a concession was made by the counsel appearing on behalf of the Union of India that even though no presenting officer was appointed, that in itself may not vitiate the proceedings. But the inquiry officer in this case had compromised his position by acting as both the judge and the prosecutor. If I may invite my Lord's attention to the relevant paragraphs, and at this point, the learned single judge allowed the writ petition and granted all the consequential benefits to the widow of the original writ petitioner who had already been substituted.
No such type of allegation. No such type of allegation is writ petition, my lord.
Huh?
No such type of allegation, my lord. Fresh
Type of?
allegation against the inquiry of my lord. Fresh.
May I please be permitted to place
No,
some?
there can't be any allegation. How he can discharge a dual role, both inquiring officer and presenting officer?
There are no any provision, my lord.
Huh?
कोई provision, there are no provision for presenting option, my lord.
Then the inquiring officer is not biased.
Yes, my lord, the case
The
was,
inquiring officer is not biased because he is taking his own documents and proceeding.
maybe, my lord.
Huh?
If any procedural lapses, the court should transfer the case for fresh inquiry, my lord.
Any Supreme Court decision is there that presenting officer need not be appointed?
Yes, Your Lordship, the reliance
yeah.
was placed on, it's recorded in the impugned judgment itself. Reliance has been placed, my lord.
Civil appeal number 23 about
Ram Lakhan Sharma's case.
Ram Lakhan Sharma case, my lord.
Where is that?
Your Lordship, if I may be permitted to place some of the paragraphs.
No, in that case, presenting officer,
Yes, Your Lordship.
Yes, my lord.
It's recorded in the page 7 of the impugned judgment. Page 7, internal page 7 of the impugned judgment. The issue relating to the. May I read, ma'am?
what is the citation?
2018 volume 16. Sorry, 2018 volume 7 SEC page 816.
Where do you get that?
Your Lordship, because it was the paragraphs have been recorded in the impugned judgment itself. The citation is not given, but
On page 6 it is there.
Yes, Your Lordship, page 6 is there.
Appeal.
G.
But it is not reported.
At that time, it was not reported, my lord, because we had just had the benefit of this. In fact, the case was adjourned so that we could have the benefit of Ram Lakhan Sharma's decision. It's recorded, my lord, in the impugned judgment.
What do you say about that decision in?
I have stated in para 11 of the.
Huh?
I have stated in para 11, my lord, detail about the judgment.
Stated what?
Regarding his judgment, my lord, Ram Lakhan Sharma case.
In which paragraph?
Para 11, page 14.
We will not accept your para 11. In which paragraph the concession made by the?
Yes, Your Lordship. May I please read from page 3 onwards, so that just a brief history of the hearing of the case.
No, we don't want history. We want their admission.
Page 9. After the Ram Lakhan Sharma's decision has been recorded, the relevant paragraphs, page 9. There is no contest on the issue that no presenting officer was appointed for the proceeding. Rather, it is the inquiring officer himself who acted as the prosecutor as well as the adjudicator.
Only thing is there is no contest. They have not given concession
Your Lordship,
as you contended.
yes, Your Lordship, but before that, certain issues had been framed by the learned single judge in course of the hearing of the matter, and the records had been called for.
They are not considered. It is the only thing is that they did not answer.
I have interpreted this as a concession. In fact, my lord.
You can't use such a
Your
word.
Lordship,
Show us that the Learned Council for the Union of India has given concession, has said that he has no
there is
issue in respect of presenting officer.
no contest, my lord. There is no contest.
Lot of difference between contest and concession. Who is this? Respondent.
Tension only. Here to the court, no? Not that. The impression given is as if considered. He can't go beyond the fairly submitted.
What do you say?
In this case, my lord, my point only, my lord, the very honorable thing they have decided on the basis of presenting option, my lord. But that was no such case before the court, my lord. That one was
No, it's all right. What is your contention? What is wrong with the error of the, what is wrong committed by the learned single judge?
in this case, my lord, my case is no question of presenting option, but there was no provision.
That is the only issue?
That was not the issue, my lord.
No, according to you, that is the only issue here. Any other issue is required to be decided.
But there is no such thing, my lord.
If I may just invite my lord's attention to page 4 of the impugned judgment. The issues have been recorded based on what we had submitted before the learned single judge. And the statement made by the Union of India was with regard to these issues that were framed.
We will reject the appeal. No, yes. I did after school decision.
Yes, taken. Present LPA is filed by the Union of India and others against the order of the learned single judge dated 2/8/2018 as in CWJC 6035 of 1997. This is the Ram Bilas Chaudhary. What was the post held by him?
Constable.
As a constable. The CISF organization was subjected to disciplinary proceedings and it was concluded in imposition of penalty of dismissal from service on 30th March 1996. And it has been affirmed by the appellate authority and revisional authority on 12/8/1996 and 10/5/1997 respectively. The feeling agreed by the impugned actions of the appellant, deceased Ram Bilas Chaudhary, filed a writ petition It was admitted on 17/11/1997. During the pendency of the litigation writ petition, deceased Ram Bilas Chaudhary died, and legal heirs of deceased employee were brought on record by order dated 28/7/2003. Following are the issues taken note of by the learned single judge in page 4, A, B, C, D, E. You have to extract that. Para 4 of the single judge order. Next, learned counsel for the appellant submitted that learned single judge has committed error insofar as holding that this inquiring authority has acted dual role, both presenting the case on behalf of the department and inquiring officer. So on this point, learned counsel for the appellant vehemently contended that CRPF rules 1959
CISF.
CISF Central Reserve Police Force rules.
Central Industrial Security Force.
Industries.
Central Industrial
Security Force.
Security Force rules, 2001 within bracket for short rules 2001 do not provide in appointing the presenting officer in respect of a departmental inquiry to present department before the inquiring authority. Therefore, cited decision namely Union of India versus Ram Lakhan Sharma, civil appeal number 08 of 2012, has no assistance.
2012.
2012 only, I said, has no assistance. Disciplinary authority is required to abide by the regulations governing the employees of the CISF. Therefore, the learned single judge has committed error in taking note of the assistance of Union of India versus Ram Lakhan Sharma, cited Supra. Do you have a copy of the rules?
Bishop, I have one copy.
Which is the relevant rule for the purpose of holding inquiry?
Rule 9.
Rule 9 is
Penalties and
no duties of managing director and general manager.
Lordship, I have CISF rules 1969.
Central Industrial Security Force Rules 2001,
I have 1969 rules.
1969, that is relevant. Give the,
I'm sorry, I only have one copy.
instead of 2001, you mentioned 1969. For short, rules 1969. Rule 9 is arrest. Which is the inquiry?
Judgment level.
Not applicable. 57 is the.
Rule 34 of rules 1969 is relevant for the purpose of procedure for imposing major penalty. Sub-rule 4 of Rule 34 of Rules 1969 reads as under. In the light of the aforesaid provision, question of appointing presenting officer is not warranted. Thus, the learned single judge has committed error. With the per control and counsel for the respondent submitted that there is no infirmity in the order of the learned single judge. It submitted that even though Rules 1969 is cited in respect of appointment of presenting officer in a departmental inquiry, in that event, inquiring authority cannot act as a both the presenting officer and inquiring officer. So therefore, there is no infirmity in the order of the learned single judge. Further, it is submitted that respondent, the apparent counsel had admitted that the presenting officer was not appointed.
There was no
Therefore,
provision.
once a concession/undertaking is given by a counsel or conceding, in that event, LPA is not maintainable. On this issue, learned counsel for the respondent relied on apex court decision, namely 1982 2 SCC 463. Write down the party name later. Para 124. Item number 2, 2020, within bracket 2020, 13 SCC 188, para 2, 12, 13. Next, serial number 3, within bracket 2011, 12 SCC 658, para 12 to 14. In the result, LPA is not maintainable. Heard the learned counsels for the respective parties. Question for consideration in the present LPA is whether in not appointing the presenting officer in a departmental inquiry, whether inquiry proceedings is vitiated or not. Next, whether whether LPA is maintainable or not in the light of submission made by Mr. Sharan on behalf of the appellant before the learned single judge or not. Make it reverse. First one, second one is first. Huh? The additional solicitor general, the then additional solicitor general. Facts are not disputed so far as the initiation and completion of inquiry against a respondent, and further affirming the order of the disciplinary authority insofar as imposition of penalty of dismissal from service by the appellate and revisional authorities. We'll stop. Next paragraph. The learned counsel for the respondent resisted the maintainability of LPA on the sole issue that the then additional solicitor general has fairly
Assistant Solicitor.
assistant solicitor general fairly submitted that the present matter is identical to that of Union of India versus Ram Lakhan Sharma. So, he being a assistant solicitor general and being a court officer of the court, he has explained the legal position insofar as presenting officer and inquiring officer, insofar as appointing the presenting officer and inquiring officer, that does not lead to giving concession before a court, before the court of law, so as to uphold the contention of the respondent that there was a concession or an undertaking given by the statement made by the learned Mr. Sharan so and so on behalf of appellant in the writ petition. Therefore, the learned counsel for the respondent's contention that LPA is not maintainable is hereby rejected. Next paragraph. Question of presenting officer is to be appointed to defend the case of the department before the inquiring authority is necessary. Otherwise, inquiring officer cannot play a dual role of presenting officer and inquiring officer. It is quite natural if he is acting as a presenting officer, he would be biased and he can't take a different view as an inquiring authority. No doubt, CISF rules 1969, in particularly subsection 4 of subrule 4 of rule 34 do not provide for appointment of presenting officer to present the case on behalf of the department before the inquiring authority. At the same time, in the absence of provision for presenting officer in a departmental inquiry cannot be ignored in the light of Apex Court decision in the case of MDECIL versus B. Karunakaran. One of the principles laid down by the Apex Court in the MDECIL case is if there is no provision in providing show cause notice along with the inquiring officer's report, even in such circumstances, disciplinary authority is bound and duty to provide an inquiring officer's report along with the show cause notice, and in seeking explanation of the concerned person, the same principle would be attracted in the present case. Accordingly, in non-appointing a presenting officer to present the departmental case, and inquiring officer acting dual role of presenting officer and inquiring officer would vitiate entire proceedings. Therefore, we find no infirmity in the order of the done single judge dated so and so, read with the Union of India versus Ram Lakhan Sharma, cited supra. Accordingly, the appellants have not made out a case, hence LPA stands dismissed.
Your Lordships, if I may request my lords to record that they may comply with the directions given in the law.
We can't do anything.
Learned single judge has
You give
granted
it to-
consequential benefits.
Huh?
Learned single judge has granted
You
consequential
file a contempt matter, madam.
Apply.